Okay, so I have talked to pretrial in regards to the violations as to tampering with the SCRAM.
You need a translator anyway, right?
I guess
Did you get
so.
Ramirez?
Yes. So, pretrial doesn't know exactly what was tampered with. He does work in construction. He wears boots, he wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like BAC, no alcohol, nothing. It was just
Because a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to...
Let's break this down, folks. That ankle monitor, called a SCRAM, detects alcohol through the skin. So when it's not detecting anything for 10 hours straight, that's a red flag bigger than a courtroom objection. And that excuse about neuropathy lotion, is it legit or just a clever workaround? What do you think? Comment below. Did he
Let's break this down, folks. That ankle monitor called a SCRAM detects alcohol through your sweat, 24/7. So when it stops detecting for 10 straight hours, that's not just a technical glitch. That's like yelling, "I'm hiding something." Now, neuropathy cream. Real issue, or real excuse. What do you think? Tamper, or not? Drop your verdict in the comments.
tamper, or is it just a medical mishap?
evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 in the morning so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one,
And it says alcohol was detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first.
Tengo que te estás, que tienes alcohol en tu sistema y que estás fallando con la máquina también. No, sir. La máquina me dice otra cosa. I don't know what to tell you, Ms. Solis, but
oh, I mean, pretrial doesn't have knowledge as far as like what was tampering. I mean,
they can't. It's impossible.
I know that, Judge.
All we know is that the device is not detecting his skin for a certain period of time, and at the same time, the alcohol is detected.
¿Dónde estabas el día primero y el día 8?
So let's do this. I need to get a translator here so I can properly translate and let him know what I'm going to do. Oh, Plaza.
Yes.
Can I borrow you for a second, please?
Boom, there it is. Alcohol detected right after a known tampering event. That's not just a violation, that's a courtroom powder keg. And guess what? The case has been dragging on for over 200 days. The judge, fed up. The defendant, still offering lotion excuses. But here's the twist. Second tamper, no alcohol. Coincidence. Or calculated.
I just need you to help me translate.
Oh, okay.
Mr. Ramirez.
Boom, there it is. Alcohol detected after a known tamper event. That's not just a violation, it's a potential violation with consequences. And with 207 days on the docket already? This case is aged like courtroom cheese. The judge is clearly losing patience. But here's the twist, no alcohol on the second tamper event. Suspicious or coincidence?
Instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
Serious consequences, repeated warnings. And he still violated. This is the moment where most defendants realize the courtroom is no longer listening to excuses. And neither is the judge. What would you do if you were in the judge's shoes? Jail now, or one last test?
I know, Judge. I mean, we're ready for plea today, but it's just what I'm.
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does say, he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the SCRAM, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol is detected and he's tampering with the device.
Okay, all right, Judge. All right, well, so I'll step out and then, okay, thank you.
What's up, man?
I'm here for Ricardo. He just said he just wanted to
Ricardo.
for an admonishment. So
Kim is here.
Oh, Dave's there. Okay. Hey, Dave. Sorry. Sorry, man. I've been in different.
This is that rare human moment in court. Both sides tired, overworked, and trying to figure it out. Even the judge jokes about a flat tire. But don't let the humor fool you. Beneath it is the weight of a man's fate hanging in bureaucratic limbo.
Courts.
okay. I mean, if it's just for an admonishment, then I can just sit here. Like if it was something contested, it'd be different. But it's just literally it was the judge. It was the one we approached on Monday for the remand, and it's just I guess telling him about.
Do you want me to bring him out?
Yeah, let's bring him out. Can we bring out Mr. Joshua Sweat? Because I did want to talk about the reason why they're asking for an extension. And I talked to the client and I need to bring this up. So.
Not happy?
Well, it's part of it. I think you're saying that he's medically unfit to be transferred. I think that's the reason that.
Right. So, I mean, in plain speak, he's detoxing, and medical needs to figure out when they're finished with that before they can even, Louisiana can even initiate the transfer. That's the issue, is they can't even tell when they're coming because he's not cleared yet for transport, ironically. So, yeah.
So that's something that I want to address with client being here. Yeah, and sorry I waited till the end on this, Judge, but I've been running around. It's one of those days.
Hey, we're all feeling. Don't worry about it. You're doing great. I'm tired too. And I still got to go fix a flat tire, man. I had a flat tire. Come on.
Oh no! Hey, Judge,
Huh?
you have AAA? You don't have AAA?
No, because through your insurance, you have roadside assistance. Yeah. I'm not gonna ask. Forgot to call him though. Hey,
How you doing, sir?
how are you, Mr. Sweat?
Pretty good. How about yourself?
Well, let's talk. You know, I think that you, if I remember correctly, you have a parole violation out of.
Louisiana judge.
No, Michigan, sir.
Or Michigan. Sorry, Michigan. I'm sorry. I conflated two cases.
That's right. He was a Michigander. That's what we were saying. That's right.
Yes.
You know, a lot of times in life, you really have to read the fine print. You got to read what you're signing. A lot of people just sign just because they want to be done with it. Yay, I'm getting on probation. Yay, I'm getting on parole. Let me just sign what I'm going to do. You know, one of the things that you sign in the jurisdiction where you signed, where you you waived extradition by signing the document that you agreed to be on. So whether you agreed to get on parole, whether you agreed to be on probation, you refused extradition by signing the document in and of itself. And it says there, I will, waive extradition if I ever become a fugitive from justice. You are now a fugitive from justice, meaning that you're wanted out of the
Here's the part most people never understand: signing a pre-signed waiver is like writing your own extradition ticket. Whether it's 14 days or 30, you're not going anywhere unless both states and medical *** clear it. This isn't just about law. It's about liability and logistics.
The state.
Yes, sir.
So you can't sit here and say, you know what, I want to try to get a bond so I can just go turn myself in. You have already you have what's called a pre-signed waiver. You have already signed.
Yes, that's why I was trying to get back.
We are going to get you back.
Yes, sir.
The problem is that sometimes, we give them up to 30 days for them to come get you from Michigan.
I was under the impression it was 14.
In the typical instance where I don't give someone a bond, but for pre-signed waiver cases, it's 30 days.
Judge, and if I may, that's my argument. When we did all this, we always talk about the practice of 14 days. And so when we originally talked, we reset it out 14 days, and we were all basing it on the 14 days. Now, the extension that they're seeking is, my understanding, because he is detoxing. And at that point, my question is, I talked to him when we talked about the 14 days. We understood each other. He understood me. He seemed fine. I talked to him again today. He seems fine.
And he may be fine now, but when he probably first got here and when everybody was notified, it may have been a different story. He may have been like, just...
No, I talked to him when we talked about the waiver, Judge.
Yeah, I'd been off my detox medication by the time I signed my waiver. I was no longer on even any detox medication.
And so my argument, Judge, I get it. And my argument is, hey, he's ready to go. We don't need extra time. Why are we holding him here extra days? Yeah, he signed the pre-signed waiver, but we talked about 14. If they're supposed to be here in 14, that's the practice. He's good to go.
That's not the practice for pre-signed waivers. It's not right. The 14 days, and understand the 14 days, hold on.
Yes, sir.
The 14 days
Yes, sir.
is us being nice, because statutorily, it's 30 days. Even in the instance where if it were a 14-day thing where I'm going to give someone a bond or this or that, statutorily, it's 30 days. We do 14 days because we have so many damn people in jail that we try to get them out as quick as possible. So as a courtesy to you, it's for everybody else, not for pre-signed waiver cases. We, as a courtesy, do 14 days. But in reality, we have 30, or they have 30 to come get you. And then Harris County releases you at that time.
May I say one thing?
Sure.
It would have been 8 days ago, last Tuesday, they told me ATW. I went downstairs. They said, Michigan is here to get you. I waited 4 hours and in the holding cell. Then they said, actually, they're not coming. I had to go all the way back to the booking process again. They took my money from my account, put it in a check. I cannot go to commissary, can't go to commissary. And the waiver that I did sign, I did read the fine print, and it said they have 14 days, and if they do not, 10 business days, 14 calendar days, and if not, then they can seek an extension if necessary. My argument, I understand everything you said, and I'm not questioning I know the law more than you, but I did read the fine print.
So hold on, let's find out. Mr. Kim,
Yes, Judge.
what's the good word?
So they're supposed to be giving an update this afternoon. Hold on, I don't want to misspeak. Yes, I got an email about an hour ago, I want to say, that they should give the final update yesterday, but it's one where obviously they have to medically clear him, liability alone, in terms of, I'm not going to just, trust that he's good to go until a medical professional tells me that he's good to go for transport, because it's a liability on both, obviously, the sheriff's office side and Michigan side for the transport. We have.
You want to roll it till tomorrow to see what they say?
Well, that's fine, but it's just for an update, just because, once the email comes in saying that he's clear, I would obviously relay that over to Ricardo. So, I mean, we can roll over, that's fine, but just rolling it over isn't going to rush their decision because they already have it on the forefront because we've been emailing about it.
Do you
Because
have
it's-
any clue when they're going to get here?
Well, so once he's clear, they can book it. So I believe they said once they clear him, they can get him in.
What do you mean, once they clear him? What does that mean? He's not cleared as of right now?
That's what I mean. Is like right now, medical has not cleared him from the Harris County side for Michigan to
I
come
haven't
get
been on
him.
detox medication since the fourth
I have
day.
no idea what that means.
The fourth. I was withdrawn because I had to take Xanax, and when I came in, they gave me a 5-day detox. I haven't been on detox medication.
So let's do this. Let's roll it to tomorrow. Who do I need to check in with to see if he clears from medical?
Well, I mean, it's a sheriff's office via Harris Health, but we're already in communication with them. That's what I'm saying. It's like no one's sleeping on this. We've been actively. There's like 4 emails this morning alone. No one is. They're just making sure he's cleared medically. And so there's no magic. It's going to be in 4 hours. It's when medical clears him. And it's not something that I can force, obviously, because it's determinative of his condition. Not just the fact that he's off medication. It's the equivalent of going into an ER. They have to observe. They have to make sure he's stable and he's safe for transport. I don't know what that means. And obviously the sheriff's office makes that determination based on safety. So safety, both him and the officers coming to pick him up.
I guess let's do this. Set it for Friday, and I'll reach out to the sheriff's office to see what the heck is going on so they can go interview him to get him cleared as soon as possible.
Okay, I will have this.
I will email now, figure out, sweat, right?
If I'm being extradited to sweat. Over my understanding when I looked into it, it's the prison that wants you.
Charles Egler reception.
Whatever it was. I think I mentioned it to you. Who is
You said
this?
the Lansing tether unit, but
That thing, that's who's asking for you.
am I going to the
Mr.
county
Kent,
jail?
Day, I'm gonna CC you on this, okay?
Yes, Judge.
Give me a second. Hey, Ricardo, what's your email address?
Judge, it's R, last name Laredo.
832? Okay, I'm CCing you on this as well.
And Judge, my only argument is look at the man. He looks in better health than
No,
I am.
that's why I'm emailing now.
That's all. Thank you, Judge. Thank you. I appreciate it.
I actually have a court date set for the 16th, which would have been the day after my 14th day.
Okay. Well, Judge is doing, he's going
Yeah.
above and beyond. He's
I
trying to
appreciate
figure
it.
it out for us as well. So
Thank you.
let's allow him an opportunity to do so. So you can hear everybody trying to figure this out. I mean, everybody sees you.
Yeah.
Judge sees you. I see you.
Now this one hits hard. The judge lays it out like a cold hammer of truth. If you're undocumented, 2 DWIs don't just mean prison, they could mean deportation. That $5,000 fine. Just the beginning. So, do judges need to be this blunt? Or is this the kind of wake-up call people need before it's too late? Sound off below.
Yet he has been held in custody since when?
27th.
What is it?
27th of last month.
Is that right?
It sounds about right. I saw him.
I don't want to take your word.
Dave, do you have that by chance?
It shows that he was filed on April 1st. Oh, wait, no, sorry. It's wrong case.
331.
Oh, sorry. It's 331. Yeah.
I was held in the Pasadena jail till the 20th, from the 27th.
Not counting Pasadena.
Okay.
The point we're doing now is you look good. We're trying to make that happen as soon as possible. Get this in the, clear.
But once they clear me, we'll start over. That's like where our how many days.
They lost, how many days we lost. We're trying to figure it out.
That would be big. Okay.
Okay. So let's at least set you 2 days out to make sure, what my feeling is that, medical is going to want to talk to you to make sure everything's fine so that you're fit for transport. Once that happens, they can get the okay, the fugitive prosecutor, to let Michigan know, hey, come get him. And then hopefully they can do it within the allotted time. I've just set the email now. Let's set off for 2 days for Friday and we'll see. And hopefully that gets done.
Is the allotted time being 14 or?
I don't know yet.
Sure. We're trying to figure it out.
I don't know. I'm not going to commit to anything at this point because I don't know why they didn't clear you, when they last interviewed you. So there's a lot of other things that play to determine when the day actually is. But be that as it may, we're going to try to get you out as quick as possible.
Yes, sir.
No one's sleeping on it and no one's waiting for just,
Yes, sir.
yeah.
Thank
We're
you.
working for this.
Thank you, Judge.
Okay.
Thank you for.
Thank you, Judge. I'll reset to Friday. All right.
Okay.
Bye.
Mr. Gonzalez Dominguez, you're charged with driving while intoxicated. Second offense. Looks like you have worked out an agreement where
Quiet for a plea.
it is a true second though, right?
It is a true second, Your Honor. I believe it was just filed as first for whatever reason.
I don't. You're charged with driving while intoxicated, first offense, although it
This part hits hard. The judge just spelled out the reality, third DWI felony with up to 10 years in prison. And if you're undocumented, you're staring down deportation. It's not just a courtroom speech, it's a life-changing warning. Question. For you, should judges get this blunt more often, or is this too harsh? Let's talk in the comments.
it's a second offense. You need to understand that there are very serious consequences with this, Mr. Gonzalez. You now will have 2 DWIs on your record. What happens on the next one?
Bien, próxima. ¿Qué es lo que va a pasar? Deportación. Deportation?
If you ever
Sí, usted.
get pulled over again and an officer smells alcohol, you will be charged with driving while intoxicated, third offense, which is a felony offense. You were looking at a minimum of 2 years in prison, a maximum of 10 years in prison.
10 años.
Do you understand? If I were you, I would never get into a car, even if you've had a sip of alcohol. Otherwise, it's probably not going to go well for you. Do you understand?
Usted lo entiende. Yes, sir.
You are giving up a lot of rights by entering into this agreement today. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you accept this agreement, you are stuck with this forever. Is it true or untrue that you had a .15 or above?
Que tenía esa concentración de alcohol más de 0.1%.
Sí, señor.
¿Verdad o no verdad?
The agreement is 1 year in jail to be probated for 15 months.
Meses.
You will do a DWI, repeat offender DWI education class. You will do 1 victim impact panel. You will do a TRAS to see what other conditions you may need. If they assess other conditions, you must fulfill them. No drugs, no alcohol, no breath test refusal. If you are pulled over in a car and an officer asks you to submit a breath test, you must do it while you're on this probation. If you do not, then you're in violation. I'm telling you now, Mr. Gonzalez Dominguez, I'm going to do everything in my power to protect my county at all costs. And apparently you have not gotten the message. So now you will be required to pay the DPS supervisory fee and the court costs. You will now be leaving here somewhere in the neighborhood of around $5,000 in fines and fees. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. And if you're not a citizen of this country, you're not here with permission, if you go to jail for that kind of time, you will probably get an immigration detainer. Do you understand?
¿Usted lo entiende? Sí, señor. Yes, sir.
I'm suspending your ability to drive for 1 year. You must also obtain does he have a portable device now, or what does he have?
SCRAM on right now, Your Honor.
Okay.
We are asking for the portable since he will be in.
So once he gets the portable device first, then we can take off the SCRAM device.
Yeah.
I have been paying for all of your devices as of now. Going forth, you will be required to pay for everything. If you fail to pay for it, if the device goes into lockout, so will your probation.
Y también su libertad condicional.
You must do a $100 donation to Mothers Against Drunk Driving, 30 hours of community service.
Arias.
Do you have children?
¿Tiene hijos?
No.
No.
Okay. You will be required to do the 30 hours of community service.
Arias.
Is this how you understand the agreement?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty, and I'm going to follow this agreement. How much is the total?
Judge, you said you were gonna do a 1 year flat driverless suspension?
Correct.
So with the driverless suspension is 4,900.
No, but it's 45 for the
45.
supervisory, and then what are court costs?
Oh, so the DPS fine is
4,500.
and then the court costs are 420.
How much?
420.
420?
420.
You will now owe $3,920. You will be given a 2-year payment plan to do it. If you fail to pay, like I said, 1 day for every $100 you owe. Somehow we have to get your attention, and I hope this is it, before something drastic happens where you end up with a 50-year sentence. Good luck to you, sir.